But what really happened here was, number one, the city got caught in its own dirty tricks that had been engaged in with the court system. Now, whether they were complicit in that, I cannot say. I don't know.
All right, welcome folks to another edition of Talking Racine. Looks a little different up here. We're in a different studio, and we have some different people. We have Jim McClain over here on my right, and Harry Waite over on my left, your right. And we're going to have a little fun with the legal case here today. Jim had what I would say. I mean, I'm a property manager. I've seen something like this many times.
Yes,
where you've got a house, and by the way, the requirements are that this house be safe. It must not affect the health of the people nor the morals of the people. We're concerned about all those things,
right,
as well as maintain property values. And when our producer, another Jim, when Jim Spotted puts your building up, people are going to see this did not violate the health, safety, and morals of the people, and certainly wasn't affecting the property values. Now, there were a few things, if you could get a microscope up there,
yep,
you might find out that, well, there's some trim boards that need a little work on it. There was a little paint that was chipped. There was some balusters. Now, balusters, some vertical things. They have to be every 4 inches, folks, those balusters. Otherwise, all hell could just break out. Racine could fall off into the Lake Michigan if those balusters weren't every 4 inches.
It is a very dangerous
very
thing.
important. That's right.
Very dangerous.
But that was there. But the real kicker was the shingles.
Yes, sir. The shingles.
All right. Do you want to tell us about? Well, first of all, they give an order to repair the shingles. Actually, it says you're ordered to re-shingle the roof.
Yes.
Which my experience is they have to do that, and I've gotten orders like that when there's only 1 or 2 shingles on a perfectly good roof that have blown off in a recent windstorm. But
right,
they still say re-shingle the whole roof.
Oh,
yes. Now, the reason they have to say that, because there is nothing in the ordinance that says fix the roof. It's all about what a roof must be, how it must be put on, installed. So the only thing to do is to order it to be replaced. So what was your action when you got these orders with regards to the roof? What was your position on it?
Well, my position was I wasn't trying to not do the work, okay?
Right.
Because I saw, that the roof, could be replaced and it would be good to replace the roof. And, the wood that had rotted needed to be replaced. Had no issues with any of that. But we don't have it, here right on the camera right now, but you all know, both you, George, and Harry, I get around with 2 canes like this. I can't, walk very well. And other than having, at this time in my life, a little bit of extra income, from rental income, and yourself being a landlord and property manager, that the actual money you make is so very little.
A roof wipes you out for like a year.
Oh, it wipes you out for many years.
Takes it off, yeah.
And because of the height of the roof and, the whole combined work that they had required me to do approximated $25,000 worth of work. And
now, who came up with that estimate?
I went to several different, contractors. That included the roof, dealing with the paint, dealing with the wood. But the primary expense, the roof itself, because they required the roof of the house as well as the roof of the garage to both be replaced. And the roof work itself was costing between $18,000 and $20,000 for the roof on the house, because of the amount of work involved as a tear-off.
Not real huge roof.
Exactly. No. It's a big roof and these types of things. So I didn't really, I wasn't objectionable to doing the work, but what I did know definitively based on the written ordinances, the roof did not, break the ordinance. It was actually in compliance with the ordinance, and the city never ever demonstrated that it wasn't in compliance with the ordinance. Their only argument ever was, well, it's deteriorated. Right. And so everybody's roof, day one after you put it on, there's some level of deterioration. So what is the city going to do? Have everybody replace their roof every day? It's kind of ridiculous, isn't it?
Now, Harry, set the stage here. This turned out to be a real. I mean, we're not talking about just 15,000 now.
We're now talking. Well, when you look at this case, and why we're here is because of the legal implications that Jim went through. And when you talk about maintenance of a building, this was, I think, way over the top what the city did, because during the civil process of bringing Jim into the court system, they threatened Mr. McClain with over $312,000 in fines. Now, this is noteworthy because this wasn't a large commercial building worth millions. This was just a simple house valued at $70,000.
1/4 of that, yeah.
Yeah, one-fourth of that. So they wanted to literally tax Mr. McClain, 5 times the value of the house. McClain, yes, excuse me, McClain, yes.
Yeah.
That's an amazing feat to take a little order like this, a couple of shingles are missing, and turn it into $300,000 worth of
fines.
It just shows where we're going in some of the things with the city of Racine.
Yeah. Now,
it's go ahead.
Now, what makes this case noteworthy is Mr. McClain went through the complete legal process through Rob Weber's civil court, the municipal court of Racine, and in the end, it went through trial, and Weber had fined Mr. McClain over $50,000. Now,
$50,057.04.
That was the award that was assessed against.
4 cents that I really want to know about.
So last straw.
So does the I'm going to say the crime fit the fine? I mean, we have people in Racine that's involved in drive-by shootings. They get fined. They get a bail of $2,500 and they're back out in the street. How is this endangering the city and the people in any way?
Was the roof leaking?
No.
That's another part. The roof wasn't leaking.
Not leaking. As a matter of fact, there was testimony given by the potential buyer of the property at that time in court that the roof on the inside in the attic was dry as a bone. His exact words to the court: dry as a bone.
So how do you think what did you do to irritate somebody in Racine to get this type of special attention?
Let's go back to where you were challenging. You were saying about the weight of the roof, the legal status. Well, because somewhere in there is where you punched a button there someplace.
Oh,
absolutely.
And I look at this thing and I get the impression of, how dare you, Mr. McClain, to challenge us.
It was something like that.
Relative to what, we have determined that you need to do and that you better find the way to do, or we will string you up by your thumbs if we can, or whatever else. And, it just, I knew that we were going to trial because when you are in municipal court, the very first thing that will happen to you is, before you go to trial, the city attorney will take you back into the little conference room that they have there, and then they will basically try to intimidate you with what they're going to do if you don't agree to plead guilty to something, actually in this case, that I knew I was not guilty of. I knew the city could not prove the points of its claim, and if I would not agree to plead guilty, they were going to come after me in New Orleans words, for $300,000 plus. And when it went to sentencing, she asked for a fine of $312,000 initially be assessed against me in the court.
That's in the municipal court before Rob Weber?
Right. Okay. And you would say, well, I'd like to check that court record, but, being the way things are, I requested for the appeal my court records and to be able to get a transcript from those records. And I got a letter from Judge Weber saying, due to some technical difficulty, we cannot provide you your records. They're gone, but you're going to get a jury trial. Have a nice day.
Now, and a jury trial would be over in circuit court.
Yes, okay. Sir. I appealed for a new trial in circuit court with a jury trial.
Now, this is real interesting because it used to be you could get a trial de novo, which means a brand new trial. You start all over. Forget all the thing that went on in municipal court. It's brand new trial, and you could just get that after you've been to municipal court.
Right.
Then the law got changed to say that before you could demand the trial, you had to pay the full amount of the fine that was assessed against you in municipal court. Now, is that your understanding of it?
Well, but the law has actually been changed. They changed that law because it used to be
very
exactly as you said. The statute called for trial de novo. You were appealing
you
for
could automatically
trial
get a trial de novo,
which means it's as if the first trial never existed.
De novo is new. New. Yeah, so it means it's all over.
But now what you appeal to is against the judgment with an appeal for a new trial in circuit court. So you start off with a new trial, but it's not the same as if nothing had ever.
It's not a clean slate.
It's not a completely clean slate.
But it's not just a pure appeal either.
Right.
Because you are getting another trial.
Right. Exactly.
Now, how do you get by the paying of the $300,000 before you can get that trial?
Well, they did not fine me $300,000.
How much did they fine you?
They fined me $50,057.04.
That's what I saw. Now, how did you get around that though? The $50,000.
Well, now the city, when we had the status hearing for my appeal to circuit court, the city attorney brought up the fact that in statute 800.14 that they were entitled to ask for bond, and they requested bond, and Judge Weber graciously waived my bond to go to circuit court. So I was able to go to trial at circuit court with my bond waived.
But you still had to
Otherwise, I would have had to come up with $50,000 potentially, although I think that they were willing to just have me come up with $500 some odd relative to that. But still, for me, that was a huge thing because I didn't have it.
No, and that when I read that in the statutes, because I ran into it in one of my cases, I thought that's very oppressive. I didn't even know the law had been changed. I always assumed I could get a trial, which was very reasonable. But now went into a different type of style of appeal where you had to first bond or pay for the fine or whatever it was, the judgment, and then you could appeal. So at any rate, at least Judge Weber, gave us that little break. Yeah, he said, all right, he's going to waive the bond, waive the $50,000, and go ahead and you go and get your trial.
And I truly am thankful that he.
No, that was decent. That was very, the $30,000, Judge.
$50,000.
$50,000, Judge.
$50,004.
But waiving it so that you can appeal.
$50,057
and the 4 cents.
And don't you forget that 4 cents.
How they come up with these numbers, I don't know. This is but the story is more interesting here now, Jim, because now you make your appeal into the circuit court. And the first thing that you see that you're initially going to be assigned to Piantek by the court proceedings. Right. And then you see that the city makes a request for substitution to have Eugene,
Yeah,
Judge
absolutely.
Eugene, however you pronounce his name.
Gassiakevitz.
Yeah, you can try pronounce it. I can't.
Yeah, I've learned how to say his name. You know, I had the hardest time.
It's the way it's spelled.
So now
You're
you're faced looking at Eugene's court. So tell me, how do you feel about going in front of his court, and who'd you talk to in order to decide that you really didn't want to be in his court?
Well, I was extremely aware of the situation with Sandy Widener's, Alderwoman Sandy Widener's case for the petition for mandamus that was in Judge Gassiakevitz's court, and all of the dirty tricks that had been played out in that because of all of the reporting in the news. I was extremely aware of what he had been involved with there. Everybody who I know who has ever been in his court as a landlord has had nothing to say to me other than the demeaning nature in which he treats anybody in his court. And basically is waiting like a lawnmower to just chew them up.
But go-to judge for the city?
Oh, absolutely. He's the go-to judge for the city.
And I got to throw something in here. In case the judge is ever watching this, because I've been in the back room with him in a court case with a tenant. And he treated very fairly. If he got on the tenant a little bit even for having, you know, and asked me why I didn't have late fees and some things like that. So I appreciate what you're saying, and I can see what you do, but I'm just going to put the record straight with regards to my experience. It wasn't quite that bad.
Maybe that's only one experience, and maybe you're the only positive one that we know of, because...
Well, maybe he watches Talking Racine. He said, I better cut this guy a break because he's on the air. I'm not. Just kidding. I don't think that's the case at all. But I just want to put that little bit in for the judge on
There
that.
were two factors, though, that really drove my decision to file request for substitution once I received the notice, and I had a certain window of time with which to do that. And it was based on what I knew of Sandy Widener's case, and also based on what other landlords had told me about their experience. Now, their experience was not, as, equitable, if you will.
Mine might have been more clear cut, too. I mean, mine was just a rental thing. He hadn't paid his rent. And there wasn't much to argue about there. There were no conditions of the unit or anything like that was involved.
But I had made the decision right then and there, you know what? I'm not staying in this court, and I knew that my rights under Wisconsin 801.58 were such that I had a definitive right that was not violatable to have a new judge if I file timely and in proper form.
You have a certain number of days, and it's automatic.
And which you did, correct?
Which I did.
And what happened then?
Well, what happened then was I didn't get any feedback, relative to my filings, and I noticed when I finally looked at CCAP that I had filings that I had made that were not even in the court record. And so on August the 5th, I wrote a letter to the clerk of courts, Samuel Christensen, and I asked about that. And lo and behold, the very next day, the filing that was missing at that point was in the record, and immediately my request for substitution and application for specific judicial assignment were both denied immediately. And the way I learned about that was I didn't get notice as I should have received under Wisconsin 801.14. But I called Judge Gassiakevitz's assistant, the clerk assigned to his court, Jamie, and she told me over the phone these things. And so that was the way I found out that my...
So you had made a legal request?
Otherwise, I wouldn't have even known that my request was denied because I didn't get proper notification from the court. And on top of that, the window for me to,
request the
substitution for it to be reviewed
was closing very quickly.
Mm-hmm. And so, it was basically, a setup, the way I looked at it, for me to be just, hammered into a judge
locked into that court.
So
you right in there.
The basic thing is the request for a new judge was denied, but you weren't notified of the denial.
Absolutely, notified.
And you were looking for
Yeah.
a notification, and that's what alerted you. I got to find out what's going on.
Exactly.
And then when you found out what was going on, that gave you a little. You made a quick move then at that point, right?
Absolutely, I did.
And then what was that move?
Well, the initial move that I made was I filed a motion for reconsideration of my request for substitution.
There you go.
And I, laid out in that motion all of the issues related to it and the statements of the actual statutes that govern it. That show that, as long as it's filed timely and in proper form, there's no choice but to grant it. And then, we were coming up on the end window, and I was reading in 801-58 again of the Wisconsin statutes, and I saw that really the avenue that I had to take was to request a review through the chief judge of the judicial district. So
that's very good, Jim.
Which is Jason Russell.
Yeah, that's
exactly. That's Jason Russell out of Kenosha. And so what I did was on August the 16th, I filed that request for review by serving it to the court by fax. I served it to the city attorney by fax, and I actually served it to Judge Russell's office by fax as well. And my filing, which to that time pretty much right to form, was not entered into the court records. Again, as a matter of fact, even to this day, now that the court case is even closed out, there are multiple filings that I did that the clerk of court never entered into the record, but they are well documented by the affidavits that I filed on August the 25th.
Do you think that there was some form of conspiracy within the court system to deny you some of your
I can't
rights?
see how there could not have been some type of conspiracy. In order to bring this thing to a head, I actually went to the governor's office. I went to the director of state courts, Judge Koshnick's office. Relative to the fact that my filings were not being entered into the record, I went for direct communications to Judge Russell, and finally, at the very last minute, right when there would have been no, chance that my filings would have been noted, Judge Russell's office, his clerk, sent a communication, and then 2 days later, Judge Gasiukevitz relinquished my case, and my application for specific judicial assignment was honored.
To Judge Fredrickson.
To Judge Fredrickson, that's correct. And I had requested Judge Fredrickson specifically.
So you start moving your pro se. Now this is something that the folks should actually understand, that Mr. McClain was acting pro se. He was acting for self, and he did all these filings by researching the statutes and by asking a lot of questions and getting some pretty good advice from several people. And so Mr. McClain continued this process, pro se, now into Judge Fredrickson's court, moving this case forward. Now, what's really important to understand, we had a case that was in municipal court. Mr. McClain he's threatened with $312,000 in fines. He's found guilty of over $50,000 in fines and penalties in municipal court.
If I can interject.
Sure.
Even as we were going into, going into the first status hearing I was offered a settlement, which I didn't accept, that was offered to me. And I was told that, well, if you don't accept this offer, I'm not trying to threaten you, mind you, but, we're going to be going after you for a whole lot more money.
And that's how they intimidate people. And suppress people.
Well, and this is where we get back to the way government is functioning today. It should not be functioning in this manner. This was a simple case over some shingles that were a little bit worn on a roof that doesn't leak.
Yep.
And to put someone through this much trouble and this much work and this much threat is just not commensurate with a free country. The way the city's supposed to be operating.
This is not how our forefathers designed it.
No, that was envisioned for the United States of America. And
when you read the Constitution of the United States of America, the 8th Amendment deals with this specifically. And the fine and penalty that was imposed upon me is so disproportionate, it's just unimaginable.
Yeah. It's unconstitutional.
It
is really what it is.
Basically, what they had done was they said, well, you know what, we're going to put you into perpetual servitude for the rest of your natural life.
All right, so, Jim, you go from a case where you're threatened with $312,000 in fines by the city attorney's office. You end up going to trial. The city awards judgment against you for over $50,000 in fines and penalties. You appeal the case into the circuit court. You go through the circuit court system. You find all sorts of issues in the circuit court system. And you find that during this process that the city attorney's office really is not even properly litigating this case. So can you explain what happened there and then what happened in the end? What did Judge Fredrickson do with this case?
Well, really what brought us to the point of closing it, is something that you wouldn't even think would cause the rails or the wheels to come off the rail of this case. But what really happened here was, number one, the city got caught in its own dirty tricks that had been engaged in with the court system. Now, whether they were complicit in that, I cannot say. I don't know. I have a hard time believing that there was no knowledge,
complicity or
knowledge of the city attorney's office or conspiracy. I have a very hard time believing that would not be the case. But essentially what happened was, because my court filings did not get entered timely, what really brought the case to a close is my counterclaim that I filed against the city, which was for their failure to follow the rules of Wisconsin 80158 subparagraph 1 that required them to forthwith mail their request for substitution to both the judge and myself, much less, providing me with service, which they did not do, which they're required to do under 801.14.
Okay, just stop you here for a second.
Go right ahead.
The reason why I say that is because the city actually hired an outside prosecutor to prosecute a building code violation, correct?
Yes, a special prosecutor. And in addition to the assistant city attorney who had stepped in, a special prosecutor that they brought in. So there's really 3 attorneys, one of them being at a very high level within the city attorney's office.
The deputy
attorney. The deputy city attorney.
New Tran.
New Arn.
New Arn. Okay.
She's married now.
Yeah, she's married now. Okay, so anyway, she's the one who actually threatened you in the municipal court for the
$312,000
and actually prosecuted you in municipal court and got the $50,000 award. Correct?
Yes, she did.
Okay. So in the end, the case is dismissed with prejudice. Now, being the city had already won a verdict of over $50,000, to have the city come in and now actually draft the letter to the court to dismiss with prejudice is unheard of.
Why we're bringing this up on Talking Racine, because this is the type of thing that's going on in the city, and it's the type of thing that needs to be changed, and it's not going to get changed by the people in power. Jefferson made that famous quote, "In questions of power, then, let us hear no more of confidence in man, but bind him down from mischief with the change of the Constitution." Well, you can't have someone in power binding somebody in power down. It's got to be, who's going to do that binding? It's going to be the average guy on the street. It's up to you and me to see that happens, and that's the real. I think that's the lesson that we need to learn from what we've seen here, Jim. I appreciate you going to the work and winning this. Thank you very much for winning it.
Amen.
Harry, thank you very much for your evaluations here.
My pleasure.
And we want to thank you all for watching Talking Racine, and we'll see you in a week.